Thank you so much for joining our panel today. So every time I introduce a speaker, my understanding is that the host will switch on their videos. One can see exactly who will be forming part of the particular panel. So I'm not going to take too much time with introductions and housekeeping so that we all get to the meat of what we're actually here today. So I studied race law and justice at Fordham Law School, and I'll be previously at law.
Recording in progress.
Housekeeping rules for this particular panel. So, and unless you're a panelist when you're sort of making your own submissions. So the online attendees, if you have any questions or comments that you'd like me to share, please put them in the chat box. You're not able to, the only people that are able to do that are people in the sort of breakaway rooms in the in-person sessions. The speakers will be highlighted on the screen for optimal viewing. If you want to sort of control that yourself, you're able to as the person at the center of, as the video that will be the main video while they're sort of speaking. Also, translations are being provided in the in-person sessions in the 3 venues. So after each of the presentations are given, there will be a pause. There will be a pause of about 5 minutes, where we're giving the opportunity for the people in person to have a sort of 5-minute short summary interpretation of what each of the speakers have given. And then this will also be the same during the question and answer sessions as well. So I'm going to move on to introducing our great panelists today. So first of all, we have Kolose Ndombini. She is an aspiring academic in the field of human geography and interested in spatial justice in Southern Africa. Through the Canon Collins Trust, she pursued a master's in environmental and geographical sciences at the University of Cape Town. Her thesis, which was entitled Community Development Trusts, Brokering Property Rights on Communal Land in the Richtersveld, was awarded with distinction. Kolose is currently pursuing her PhD. The next speaker that we're going to have, so I'm giving them in the order in which they will be sort of making the presentations. So the next speaker that we'll have is Dr. Pilile Mbata, who is a lecturer at the University of Cape Town in the Department of Environmental and Geographical Science. She teaches and does research within the field of environmental sustainability and human geography. Her research interests lie mostly within the marine and coastal governance research in the Western Indian region of Southern Africa, with a specific focus on rural contexts along the coast. Last, but definitely not least, are 3 people that will be presenting together. We're joined by David Mason, who is the founder at Purportedly, and Cecil, who's a lawyer at the LRC's land program. So Colin Lowe, who's also joining them, is the chair of the Komisani Sun. Mr. Lowe is also the chairperson of the South African Sand Council, a board member of the National Koi and Sand Council, and a former chair of the Working Group of Indigenous Communities in South Africa. So without further ado, I'm going to hand it over to Kolose, who will be the first speaker today.
Recording in progress.
Okay, thanks. So I'll start off, and then Cecile will take over asking a number of questions. The way we're going to do it is LRC and Purportedly have been involved in some work with the Khumani Sand. And so what we're going to do is Cecile is going to ask Colin, who's the chair of the CPA, a number of questions. And we'll have a kind of discussion around that. So that's the format of it. And we've got very little time apparently. So just I'll do an intro and then Cecile will take over. So the forebears of the Khumani Sand lived in a nomadic manner in the southern Kalahari, in the far north of Northern Cape. Then when the Gemsbok National Park was established, the Khumani Sand was systematically removed between, say, 1913 and 65 as this park was consolidated. They then became the beneficiaries of one of the first successfully settled land claims in terms of the Restitution Act in two stages in 1999 and 2002. And a CPA then was established to receive and to manage the land. This settlement resulted in 8 farms being transferred to the CPA. It also included then some land below the Kgalagadi Park, which was the new park, that was then included, their land was included in the park as a contract park, and it is then managed by Sand Parks. The governance of the CPA and the management of the assets of the CPA on behalf of the community are governed by the CPA constitution. That constitution makes provision for the election of a management committee and a traditional leader every 4 years at an annual general meeting of the CPA or the community. On 1st of April 2021 last year, the TKLA, Traditional Khoi San Leadership Act, came into effect. And it's likely that the Khumani San will be recognized as a Khoi San community and the traditional leader as a leader in terms of the TKLA. While the TKLA expressly doesn't give land governance or management powers to traditional powers, as they assert that the customary law should determine how those powers are created and established, the councils have generally assumed this power and creating then a tension between councils and CPAs where these two exist in parallel. When the TKLA came into effect in April last year, the person who happens to be holding the current position of traditional leader became then able to apply to be recognized as a leader, and who will then have the power in terms of the TKLA to form a council and to assume the powers that the TKLA will afford to that council. This, of course, creates an inevitable tension between the CPA on the one hand and the traditional council on the other hand. So this is the focus of our discussion. We'll do this as a kind of a question and answer session where Cecile asks the questions and Colin and then I will respond to that. So perhaps I should hand over to Cecile.
Thanks, David. Colin, I just wanted to ask if you could unmute and put on your camera so we can all see you. I know Colin said that he's going to try and do a little bit in English, but there might be some part of it that is in Afrikaans, and where that happens, I'll just sort of try and give a summary at the end in English so that everybody can get a good understanding of that. Colin, then maybe what I'll do is I'll start off to asking you if you could just give us a little bit of the background to the Khumani San community, the traditional community. How was historically the approach of the Khumani San to leadership? If you can talk a bit about the different groupings, the different parts that make up the Khumani San and how they approach the process of leadership within those groupings.
Good day, everyone. My name is Colin Lowe. As I was already introduced by Ms. Boy, the Khumani San is a traditional community with different tribes and leadership in the community as well, like your Kauni, your Nganasep, your Nanke. There's a lot of groups and even leaders, bloodline leaders. But we all came together, not even all of us, but at the beginning was only the Nganasep who started this land restitution with the government, and the government then decided, and there's a lot of other San people who must join, so they can't give the land to only a certain community, but only to the whole San, and that's where all the other groups was coming in, and it got started with Mr. Roger Channels, and we, after a couple of years, we win that restitution, the land. The problem now comes in that we have now a CPA. The land was given to the community which means it falls under the CPA Act. And there's a lot of leaders in that community. So the TKL, that new act that gives recognitions to leaders, and we have some of problems at the moment. We only have one leader that was elected, not bloodline on bloodline side, but elected to serve on the CPA, because the land was given to the community and not to the traditional leader. So that's the issue here that we have.
Thanks, Colin. Colin, can I just ask, you spoke about this traditional leader that was elected. Can I ask, historically, my understanding is that the Komani San consisted of sort of 8 groupings or clans that each had their own leader. And then there was a captain that was sort of in charge of everyone. I'd wondered if you could speak a bit about that relationship between the captain and the different groupings and their leadership.
In the beginning, it was difficult. And then the community decided we need to elect one leader out of the 8 groups. So which means the 8 groups came together and they elect one leader, and the community accept that leader at the annual general meeting. So that leader is only elected to make sure that heritage, that he protects the heritage and promote it, the tradition, and even the language whatsoever. That's the role of the traditional on the CPA.
Okay, so can I ask then, why was it decided that you wanted a traditional leader to be included in the CPA, and that why was it decided that he would be elected every couple of years?
The reason why we decided to put on the leader was that the leader fell out, because now the CPA Act gives more powers to the committee rather than to the leader. So the community decided that the leader must, the traditional leader must be ex officio on the CPA, so that when there is some decisions that made, even you might have to make sure that the culture, the language, tradition, everything is included in the decisions that the CPA committee is taken.
So you spoke a bit about the culture and the heritage of the Komani San. In the current constitution of the CPA, what exactly is the role that was envisioned for the traditional leader? What is he supposed to do as the traditional leader for the Komani San in terms of the CPA constitution?
He's supposed to make sure that he promotes the culture, tradition, and the heritage. That's the only 3 pillars that he is supposed to make sure that it works in the constitution.
Okay. Colin, can I ask you, we've spoken a little bit about the TKLA, and I know that you have been very involved, and we've had many discussions about its passing and what the possible impact could be on your community. I wondered if you could elaborate a little bit on what do you think is going to happen to the position of the traditional leader, or what the impact of the position of the traditional leader will be on the CPA after the TKLA came into power.
There is some worries, but according to the TKL, it does not speak about land. It's only given recognition to the Khoi and San leaders. So it does not speak a lot of land. But now the concern is, if, and that was my question to the Commission on Khoi and San issues on the TKL. My question to them was, if our leaders apply and they will be recognized as what we have now. The CPA Act, we have the CPA Act, who give the mandate and powers to the committee, not to the leader. So when he started being where will the land be for him?
Recording in progress.
Plans, that it must meet the minimum number of times during the year with the traditional leader, that importantly, that it should hold the leader accountable, and that they jointly should be working towards cohesion within the community. So that was in terms of the role of the Elders Committee. Then in terms of the leader's role, amongst other things, we asserted in the Constitution that the leader is responsible for the furtherance of language, tradition, and cultural practice. And then importantly, we said that provided that any decisions or actions that may affect common land or assets of the community, that must be approved by the management committee. So we recognized the role was very much, as it was in the beginning, language, tradition, and cultural practices. But we just made it very clear that the power to allocate land and management of the land is in the CPA management committee. We then, it also included how this position should be elected and how what the manner of that election was. And that is through nominations by the Elders Committee and then election by all the CPA members. And then we also included the preparation and adoption of operational rules and policies of the leader and the elders by themselves. Importantly, just to finish off, the leader is no longer a member of the management committee. In the old previous constitution, the leader was a member of the management committee, and that was already.
All right, I think we can get started again. The next speaker,
Recording in progress.
The next speaker will be Colosa. Colosa, you're back in? Perfect.
Yes, thank you so much.
Thank you.
Is everyone able to see my screen?
Yes.
Okay. Okay. Apologies again for the delay. So my name is Colosa, and I will be presenting a paper entitled "The Failed Promise of Remedies: A Political Analysis of the Trust Property Control Act of South Africa." Are you still able to see?
Yes.
Okay. And the main aim of this paper is to explore how seemingly neutral laws and administrative processes that govern the management of communities' trusts threaten the property rights of people living on communal land. And to do this, I want to start by providing a brief appraisal of the Trust Property Control Act, focusing on particular sections. And then using the Richtersveld as a case study, I want to show how the minimalistic...
Sorry to disturb. Can you switch your video on?
Oh.
Thank you.
Yes. Okay, so the second objective of the paper will be to use the Richtersveld as a case study to show how the minimalistic nature of the Trust Property Control Act fails beneficiaries. And first, I want to just give a brief context of what is a trust. So a trust is a legal arrangement in which one party, a founder, gives another party, a trustee, the right to hold property for a third party, which is the beneficiary. And trusts have been a constant feature in communal areas of South Africa, from holding missionary land in the colonial era to the South African Native Trust that held most communal land in South Africa under white minority rule, to the proliferation of trusts in areas where there is mining development today. And there are two types of trusts. I'll focus on private trusts, but briefly, public trusts will be ones that have been established through an act of parliament, for example, the Ingonyama Trust. And then the private trusts, which are governed by the Trust Property Control Act. And this was passed in 1988 and ratified by the Justice Laws Rationalization Act of 1996. And prior to this, private trusts were largely unregulated, meaning that disputes were solved through the courts. And this is clear from the dominance of case law in the development of trust law in South Africa. So the Trust Property Control Act was passed as a way to provide some overarching regulations on trust. And in providing this regulation, it was a difficult task because the idea was to manage providing a benchmark for what makes a valid trust, but at the same time not overwhelming the Master of the High Court as the highest accounting officer. And it seems as though the approach that was decided was to provide minimum requirements of what constitutes a valid trust and leave everything else into the trust deed, which should give more detail into the duties of the trustees and so forth. But the Trust Property Control Act does give certain powers to the Master of the High Court. For example, the power to appoint a trustee should the position become vacant or cannot be filled, as well as the power to remove a trustee, and the power to call a trustee to account if there are any irregularities. And in this regard, Cameroon, etc., cite instances where it was considered giving the Master of the High Court more powers, but decided against it. But what I want to draw attention to is that some of the powers that are given to the Master of the High Court are phrased as discretionary powers. For example, may do this, may call a trustee to account, rather than obligatory powers. And this means that it is in the discretion of that specific master that a trust falls under his jurisdiction to do an action or not. This may have been in part in a way to avoid overburdening the Master of the High Court, but what it has done is leave a vacuum that is unfavorable to beneficiaries. And this will come clearly when I also discuss the Richtersveld. So in most cases, in trusts that are established by people who have the socioeconomic means, they will obviously have hired a lawyer and are able to draft a trust deed that clearly defines the recourse that beneficiaries may have. But in most of the community trusts that I've had the privilege of seeing, this is not the case, as they are drafted after a land restitution claim, and they're often very brief in the mandates that they put on the trustees. And this leaves a gap. And I know many of you have dealt with various Master of the High Courts, and the office is notoriously known for being highly dysfunctional. For example, in January, the Deputy Minister, John,
Recording in progress.
To obtain trust deeds, and that was an arduous process. Some of the Master of the High Court said they couldn't do so, while others were able to provide me as a researcher. So there's there's not a uniform approach that the different Master of High Courts have. And so the first challenge to communities in accessing their documents is just getting hold of the trust deed itself. And so it leaves us to question that, will the Master of the High Court then even perform the extra discretionary duties, such as calling the trustee to account and so forth? And oftentimes not the case. And so in analyzing the minimalistic nature of the Trust Property Control Act, I want to make the point that exclusion can often be there by design. Solving disputes through the courts, which is often the only other recourse that communities have when the Master of the High Court is not acting, is an exclusive process. It requires that communities have the means to access the courts and have the means to access a long legal battle, which is often not the case. Then I want to move on to the case study, the Richtersveld, in a way to show how these manifest on the ground using a case study. And the Richtersveld is located in the Northern Cape. And the Richtersveld community is made up of 4 towns, Xeenfontein, Lekkersink, Kubus, and Alexandra Bay. I'm not sure if you'll be able to see properly. But the 4 towns together form the community, and they surround the Richtersveld National Park, which in conjunction with the Hot Springs Park in Namibia all form the Richtersveld Transfrontier Park. And there's been mining that has been happening, diamond mining, since the 1920s. So the reason for choosing the Richtersveld as a case study is that it allows us to explore trust in 3 different contexts. So there's conservation happening, and then there's mining, and then there was a land claim. So in 2007, the community, after winning their land claim in the Constitutional Court in 2003, entered into various negotiations, which culminated in a deed of settlement. As part of this, 2 trusts were established, one to hold the compensation that was received by the community, and another. And so I want to bring these dual role of trust, this history of trusteeship with the present trust today, to ask, has the nature of trust in South Africa fundamentally changed? And I would argue not. In both cases, the beneficiaries, people who were land rights holders, are now beneficiaries with very limited decision-making power. And so I want to say that the emergence of post-apartheid trust in South Africa needs to be analyzed politically, not only at an administrative level to see that maladministration must be viewed as an injustice, but also to ask the deeper question: does the Trust Property Control Act continue to have an undertone of an ideology that people's property rights must be supervised? And if that is the case, perhaps it's important for us to return to the drawing board and ask these questions about the ideologies underpinning these so-called neutral laws. Thank you.
Thank you very much, Kalosa. I'm just going to
Recording in progress.
Pause very briefly, just so that the in-person venues can get a short summary of Kalosa's presentation. Thanks a lot. And then we're going to move on to Pilile, and then we'll, running short on time, we'll have a few minutes at least left over for a few questions from the audience. Thank you very much.
Thank you, Zinande. Okay, hello everybody. Can you hear me and you can see the presentation? Okay, perfect. Hi everyone, my name is Pilile Mbatha and I'm based at the University of Cape Town in the Environmental and Geographical Science departments. So I'll be talking about plural governance systems and rural coastal livelihood strategies in the Kosi Bay area, which is within South Africa's first UNESCO World Heritage Site, known as Ismangaliso World Heritage Site. So in my presentation, I'll be looking a lot at the governance systems that prevail in the World Heritage Site and how they're set up and how, and some of the issues and the asymmetries that we see emerging from this particular case study. I'm using the Kosi Bay lens as a case study just to show how governance processes impact the livelihoods of local people who live within the indigeneity to they were dispossessed during apartheid, and also during the colonial era as well. There was a displacement that happened. So in the post-apartheid dispensation, a lot of these people have been hoping that rural development from the South African government and all the interventions and programs are going to improve their livelihoods and are going to give them access back to their customary livelihoods and to the land that they lost in colonial and apartheid eras. However, with the advent of the World Heritage Sites in 1999 and its establishment, a lot of some of the dispossession that took place in colonial has really changed. Some people do argue that things are getting worse. So I'm just going to break everything down and look at some of the governance issues that result into this. Okay, let me just put my thing in presentation mode. Okay. So in South Africa, natural resources are important for people's livelihoods, and a lot of indigenous communities and local communities, and I use the word with a lot of caution, but just for the purposes of what I'm explaining, and I will explain what I mean by community in this context. But a lot of people rely on the coast in rural areas, rely a lot on natural resources, and they have for many generations, even in pre-colonial times. But obviously the ability to access physically the resources and also their rights to the resources has been impacted by colonial and apartheid eras in South Africa. So these pictures are taken from the Kosi Bay area within Ismangaliso World Heritage Site. And I will show you where the area is just now. So historically, the colonial era, as I said, resulted in the appropriation of land and resources from local people. And we saw that trend perpetuating into the apartheid era in South Africa. During apartheid, a lot of what had started in the colonial era was basically further intensified or entrenched. And in KwaZulu-Natal, for instance, on the coast, there was a lot of dispossession of local people of their land and also displacement that took place for conservation since the 1950s. Particularly in the Kosi Bay area, a lot of people remember the first time being displaced for conservation in the 1950s, when the homeland government and the apartheid government actually started this, was establishing conservation areas in the community. A lot of those conservation areas that were demarcated during the apartheid era are now under the World Heritage Site, which was established in 1999, which I'll speak about just now. But in the last bullet that I have on the slide, I think this is basically, it's been a lot, the focus of most of my research and the findings of my research, which basically is the fact that we cannot understand conservation governance without looking at how
Recording in progress.
Pretty much on the species and not on the social impacts of conservation. So for instance, a lot of conservation in South Africa is still pretty much driven by this tragedy of the commons rhetoric that basically focuses on the need to privatize resources because of their
recording in progress.
Resources. So therefore they have to follow the statutory ways of conservation that completely undermine local practices. So this idea of the tragedy of the common is still quite problematic in many parts of the global south. And we see it in South Africa, where conservation goes hand in hand with a lot of times with dispossession and exclusion of local people, not just physically from the spaces, but also in decision-making processes, which is quite an issue. We also still see a lot of undermining of local customs and livelihoods, and a lot of people in areas that are adjacent to conservation areas still pretty much lack access to their rights and also to the resources, which is a trend that has been perpetuated from the apartheid and the colonial regimes preceding where we are now. And also what is coming out of my research a lot as well is this idea of indirect rule that we saw happening a lot during colonial and apartheid eras in rural areas, where basically the states relied on traditional authorities as satellites in rural areas to govern on its behalf, making traditional authorities upwardly accountable to apartheid and colonial governments and less accountable to wider populations. So we still see that mode of indirect rules still pretty much at play in the current dispensation. And the example of customary is one example that shows how conservation governance usually takes place remotely. And a lot of conservation authorities also they ally with chiefs to basically implement some of
recording in progress.
Natural sites that are protected for their natural attributes, so mostly ecological attributes. And then you have cultural sites, most of which are found in the global north, that protect what is called cultural heritage. And then you have mixed sites that protect both natural and cultural aspects. However, in South Africa, we have more of the natural sites. And in this particular area, Isimangaliso World Heritage Sites is a natural site. So the protection that you see here is the conservation governance
in progress.
Ecosystem is definitely is then the reason why this area is protected. But you also have communities or local people that have relied on the system, on the cost-based system for centuries for their livelihoods. But that has completely been undermined by conservation interventions over time. So this is a timeline showing the different interventions that have impacted people's ability to access their rights to the land and resources in this particular area before it was even a World Heritage Site. So if you look at the bottom of the timeline, you will see that South Africa ratified the World Heritage Convention in 1997, which led to the promulgation of the World Heritage Convention Act, I think in 1998, which then resulted in this particular World Heritage Site being the first in South Africa in 1999 to 2000. But before that, conservation was not new in this community. So during apartheid, a coastal forest reserve was the first formal protection that took place from the apartheid government in the area, which is adjacent to one of the communities. And subsequently after that, there's been a lot of conservation that's been introduced in the area. But in the 1970s and 1980s, there was a lot of forced removals of local people from land adjacent to the estuary and to the coast to land that is more inland for conservation purposes. So when people were moved during the time, they were told that the government is trying to stabilize sand dunes and then at some point they will go back, but that has never happened. And the governments during apartheid worked with the traditional authorities to displace people. So in some of the oral histories that I did, a lot of the people told me that the chief actually wore the uniform of the conservation authority, working with them, going house to house to displace people. And people bought into the idea when they saw the chief working with the conservation authority, thinking, okay, that maybe we can trust this process. But I mean, lo and behold, they've never gotten back their land. So these are some of the maps. So the one on the left basically shows the different layers of protection in the area. So not only is this entire area a World Heritage Site at the international level, at national level, there are also other modes of governance, for conservation governance. So nationally, it's also on the coastal side in the blue that you see on the map on the left. There's a marine protected area. And on the terrestrial side, which is green, the green that you see, those are terrestrial, like forest reserves or conservation. So it's almost like a double layer of protection on the marine and the terrestrial side. And then the map that you see on your right is the Kosi Bay system, which I was talking about, which has this unique lake system where the estuary right at the top joins these 4 lakes. And the lakes, the big lake that you see in the middle and the one below it, the big one is a mixture of salt water and seawater, whereas the one at the bottom is fresh water, and the other 2 at the top are salt water. So it's quite a very unique system, which is rich in biodiversity, but it's protected internationally by UNESCO, nationally by the Departments of Forestry, Fisheries and Environments, as an MPA, and a coastal forest reserve. And yeah, so you can see that local people are subject to all these rules, which it can be very difficult to navigate if one is trying to go about their livelihoods. So this diagram basically shows the normative picture for governance. So internationally, as I said, okay, now it's changed, it's the DFFE, excuse that. And then at provincial level, you have Isimangaliso board and the Isimangaliso authority. And then at local level, you have all these other institutional arrangements that predated the World Heritage Sites. So then the normative idea is that all these different institutional arrangements communicate with each other and everything is working seamlessly, everyone understands each other, but obviously that's not the case. This just creates a lot of ambiguity in terms of governance and a lot of conflicts as well. And also, you know, it just makes it easy for the institutional arrangements to pass the blame to each other if the communities are complaining about their rights being impacted by all of these institutional arrangements. So one of the things that I've been focusing on is looking at this by looking at the role of history, politics, and power, and how that has impacted the governance of the World Heritage Sites, and how that has had negative impacts on the livelihoods of local people. So yeah, I'm not gonna go into this because it will take up too much time, but what I wanted to highlight is that in Kosi Bay, there is very strong evidence, which basically came out of my PhD and also a paper I've just published, showing that, you know, the customary structures and customary norms in Kosi Bay are very strong, that predate colonial times. But a lot of these customary structures on the ground are undermined by the governments. They were undermined by the governments before the colonial and the apartheid governments. They're still undermined by this current government, the democratic governments. The problem with the democratic governments is that they usually rely on chiefs as sort of their go-to people when it comes to rural areas. And whenever they include the chief in decisions, they always tick a box and say, oh, we've consulted that community. And there's a lot of literature showing that chiefs are not always representative of wider communities. There are actually locally existing customary structures that predate colonial times that still operate in rural areas that govern land and resources. But these structures are usually not consulted by chiefs because chiefs see them as a threat because they are more democratic, and chiefs are usually opposed to democratic structures as well. But they are separate from traditional authority systems. So this is why in a case like Kosi Bay, you end up not just with a statutory system.
Recording in progress.
To actually iron out the difference between the real customary structures and traditional authority institutions. Because what the apartheid government did was they adulterated customary systems and they made traditional authorities customary leaders, even in areas where they were not. It's not to say that traditional authorities are always not customary leaders, but there are areas where they are not necessarily. And Kosi Bay is a case like that, which gives us a very useful lens to understand this conflict. So in terms of people's livelihoods, people have a long history that predates colonial times of harvesting marine resources in the estuary, in the lakes, and in the ocean, and also in engaging in agriculture. And all of this historically has been managed through customary rules, which were obviously were undermined by the government and also are still undermined now. So the fact that there's a big focus on the World Heritage Site and its rules that basically prevent people from carrying forward their livelihoods since 1999, a lot of people now don't have access to their livelihoods because with the coming of the World Heritage Site, conservation governance in this area has been highly entrenched. So it's very difficult for people to maneuver, and there are a lot of threats of violence if you break the rules. And a lot of people that live inside the World Heritage Sites, where I did my research, there are villages inside the World Heritage Sites. And people there used to tell me that the government, conservation authorities that work for the government will come in and tell you not to extend your house, not to build your house. You usually speak English. And a lot of them are not educated enough to understand English. So some of them don't even know what a World Heritage Site is. Yes.
I'm so sorry. I'm gonna have to ask you to sort of hold there.
Just 1 minute. Yeah. Just 1 minute. Yeah, and then I'll be done.
Okay. Cool.
Yeah. Yes. So what I wanted to highlight here is because of the entrenching of conservation, people have had to shift their livelihoods to rely more on government grants, which is basically not a sustainable means of them to basically conduct their livelihoods. So I just wanted to end up here because I don't have time to speak about all of this. I thought I would have enough time. Basically, this is the message that I write about, the fact that the assumption is that all these institutional arrangements get along and they work together for the good of governance and also for the livelihoods of people. But the reality is that there are a lot of asymmetries and a lot of contestations between the different governance structures. And
then bathomile ka go bontsha tabela gore batho ge taba ya go fiwa naga e thoma e bolela gore ba latlhegetswe ke naga ba tlo e hwetša batho ba ile ba le tshepo e kgolokgolo gore ditokelo tša bona ka nnete di tlo ba tlo kgona go di hwetša mara se re bone se thoma go direga ya ba taba ya gore go ba le mafelo ao e leng gore ba bitša gore keng ke ao a bolokegile goba a go šireletšego re thoma go bona ka 1999 go ne lefelo le mola St. Lucia ba le bitšang gore keng is mangaliso so lefelo lela pele nako ge kgethologanyo e ba gona batho ba dula gausi mola ba iphediša kang ka go lefelo lela ba re ya ditlhapi mara e rile morago ga ba seno tšea lefelo lela ba le beya gore keng World Heritage Site ya ba taba ya gore go na le melawana e thomang go beiwa gore batho ba thoma go šitišwa gore ba ka kgona go ya gona mola lefelong lela so seo se leng gone gore re se tsebang gore gale go tloga gale batho ba iphediša kang ka tlhago e be kgona go hlokomela batho and mara jwale ga batho ba tsena ka melao e meswa ya gore lefelo le ke leo le šireletšegilego so taba eo e be e bontšha gore ba lebeletše go bolokang diphedinyana tšeo di leng gona lefelong le leitšeng go na le gore ba lebelele gore na batho kana ba iphediša ka tselamang so ka boripane se re ka se bolelang ka sona ke gore taba ye ya gore go boloka goba go šireletša e no swana le ge re bolela ka go taba yang ya go amoga batho naga because ge lefelo ba thoma ba le kgetha ba lefelo le šireletšegile batho ba dulang gausi le lona lebelo ba phediša ga ba sa kgona go dirang go ya go lona and then seo se leng gona gona bjale semakatšang ko goreng melao e ke ya nako ela ya kgethologanyo le go le sa no tswela pele mmuso o sa šomiša magoši gore mafelo a le ba kgethileng gore ke mafelo a bolokegilego ke magoši a diragong a kgontišang gore batho ga ba kgone go dirang go fitlhelela dilo tše dilong ka gare ga ona mafelo awe and re bone ona mafelo awe a thoma go bang a laola ke dihlopha tše pedi ya mathomo ke mokgatlo la ditšhaba kopano ba o bitsang gore ke UNESCO and then ka mo nageng a thoma go laola ke kgoro ela ba e bitsang gore ke a tša pabalelwa kere And then se no ra gore ka nnete batho ba dirileng ba thomile ko go latlhegela keng dilo tsela ba iphedišago ga go makatše le gono ge batho ba thomile go dira go tloga go tephediša kang ka tlhago ba phela ka di-grants goba thekgo ye mmušo o diragong o thomang go ba fa yona o ka re ka boripana ke sona se ke se kgonne go se fitlhelela.
Okay, thank you very much for all the presenters. My name is Francina Nkos. I'm based in the rural area.
Recording in progress.
I want to understand how women can be more resilient, because when you talk about land, you talk about women, and women are more affected to be relocated. You see kids who don't have a place to play, a place to continue with the knowledge that their great parents were doing. Now, how women can hold this government accountable, because if you talk about this trust, it's only there as a trust, but when you go down, communities are more affected than other people on top. Communities are the ones who are forcefully relocated and they lose their
yes we did. So I think that question was directed mostly to Cecile, David and to Colin. So I'm just going to grab the questions from Joburg and then read the comment from Durban, and then we'll let the presenters answer the question. Cecile, did you guys catch the question?
Yes, I think I sort of got a idea of what it was.
Okay, great. So we'll get from Johannesburg, and then I'll read the comment from Durban.
Okay, thanks. I'll just summarize. It's just all about women resilience, as women are more affected by being forcefully relocated, and the kids, they lose the indigenous knowledge and they lose on knowing all about how their parents or great-great-parents have survived, and we all need the land to survive. How women can build on more resilience, especially to the government. Thanks.
Thank you very much. So there seems to be two comments from Durban that I'm going to quickly read. So a comment from Durban by Umamlina was that they made a land claim in Louwburg to Minister Nkwinti, but as beneficiaries, they received nothing. The department does not want the beneficiaries to access the land, and the trustees have no voice. And I think sort of that really ties in with Ukolosa's presentation, which was talking about the lack of agency and the lack of control that that beneficiaries of these trusts have. I don't know if you have anything else to add, Kolosa, after, like, on the basis of that comment. And then another was from Usis Lirato in Durban, where she sort of emphasized the need to call the relevant departments and have them in these spaces so that the participants themselves can also reiterate and highlight the need to sort of resolve these issues and resolve their access to the land. So then I'm going to then, let me see, there are a lot of questions and comments in the chat. So I'm gonna, I saw one that was a bit shorter. So this is to you, Kolosa from Derek Faye, where he sort of makes the links between his own research in Dispossession, and that he was saying that one point that he observed is that the trust as a legal entity enabled outsiders to intervene in the community by supporting litigation based on technical failures by the original trustees. So he was wondering whether or not this is something you came across in your own research.
Thanks, Senande.
So we'll start off with Kolosa, and then we'll hear from Cecil and Cecil and the colleagues, and then Upilile can sort of round off so we have about 5 minutes. So I'm sorry, guys. I'm going to ask you to keep it as brief as possible. Thank you.
Thanks, Anande. Thanks, Derek. I haven't seen any successful interventions as yet. I am aware that after the state capture, so the Richtersveld kind of featured through Alex Go in the state capture, and in that time there was renewed effort to try and help the community. But I think in the case of the Richtersveld, the trust structure is so complex that even when there are attempts to intervene, it can get quite difficult to untangle what has been going on. And so there's also been questions around the validity of a resolution passed by the CPA, and that becomes quite difficult to resolve. But I would love to hear more about that Dosakole case.
Thanks, Kloso. Cecil and David, do you guys have any responses to the question that was put to you from East London?
Thanks, Anande. Yeah. So, I mean, I think the question was about why, don't we try to amalgamate the different roles? And I think that really was what was the process that was followed sort of last year with the changes to the constitution, was to try and in the CPA constitution, determine exactly what is the role of the traditional leader, what is the role of, the CPA, and to clarify that a bit more and make sure that those roles are clearly defined. I suppose that the two acts, the CPA Act and then the TKLA, they also do different things. So it's not easy to, for example, amalgamate the two acts. But I think what we tried to do with the changes to the constitution specifically was to make sure that a system is created that allows for the specific roles of the traditional leader and then the specific roles of the CPA to try and alleviate some of the conflict that could possibly arise because of these two structures and the two pieces of legislation. David, I don't know if you want to add anything to that.
Sorry, I think that's fine. So just to say that Colin had to leave. He's busy with negotiations around Honeybush, and so that's up to us. Sorry about that.
No problem. But thank you. So I mean, just because we really have no more time, I was just going to ask if Leela had any sort of parting sort of comments. If you've been able to sort of read anything on here, and if you want to sort of tie us off before we break for lunch.
Yeah, thank you, Zenande. No, I've actually been answering some of the comments in the chat. So I think I've attended to everybody. And I think someone just made the comments about the need to differentiate between traditional and customary institutions in rural areas, which is basically something that I'm advocating for, and it's something to think about. And I think it's relevant for this conference as well. That's all I have to say.
Thank you so much. So I'm going to thank all the panelists. Thank you so much. This was such a great panel. And everyone who participated in the comments, there were some really, really great comments and questions and sharing of papers and sharing of knowledge that was going on in the chat. And thank you so much for that. And please carry on doing that throughout the conference. And a lot of these comments and a lot of these questions, I think, will also be dealt with in sort of subsequent panels that are coming up and in discussions that will be happening over these next 3 days. Thank you everyone for participating and being here, and enjoy the rest of the panel. The conference, I'm sorry. Thank you everyone. Just in terms of next steps, does everyone then leave to the main room, or how is the process best going ahead? Going forward.
We go back to the plenary, yeah.
Okay, thank you everyone. So everyone can just leave the breakout room and go back to the plenary.